Good morning. My name is Malcolm Niekirk. Today's topic is on the Third Parties Rights Against Insurers Act 2010. Bit technical, and it's not of a great deal of relevance to insolvency practitioners most of the time. The focus of the legislation is to give additional rights to creditors where there is an insurance policy that's intended to pay out on the sort of claim that they've got. But it's worth knowing a little bit about how that may affect you. The issues I'm going to be talking about is, first of all, the why, the reason for the legislation and the difference in policy terms that it is intended to make. From there, I'm going to move on to look at the statutory rights that creditors have got, and then look at that in a bit more detail and look at how those rights are enforced by the creditors. From there, I'm going to move on to talk about the insolvency procedures that can be affected by this legislation, and then look at it from the other side of the coin and look at the duties that you have got in a case where a creditor is exercising their rights. Finally, I will finish with what I hope are some useful suggestions about how you should deal with a situation like this if ever you should come across it in practice. So let's start by looking at the why and the reason why we have this legislation in the first place. And the reason for it is that it diverts insurance payouts. In the course of this presentation, to keep things easy, I'll talk about the debtor as the company, and I'll talk about the third party as the creditor, just to keep the terminology familiar, I suppose. But the debtor doesn't have to be a company. This can apply in personal insolvency cases as well. So without the legislation, if there is an insurance claim in a liquidation, the unsecured creditors would get a windfall on the payout by the insurance company, and the particular creditor who was hoping to get the benefit of the insurance money will have only a claim ranking equally with all other creditors. So let's look at that in a little more detail. And here I've got a compare and contrast that shows what the situation was before 1930, which was when the predecessor legislation came into force, and what the current position is. So stepping back into time and seeing what the situation would be in a case where we don't have this legislation. Here, let's imagine that a creditor has got a claim against the company. The company, the debtor, passes the claim on to the insurers to deal with. And to cut a long story short, let's assume here that the insurance company pays out on the claim. This is not before 1930, remember. This is in a case where the legislation does not apply. And here, the insurance company will pay out to the company in liquidation. So effectively, the liquidator gets the compensation. And because there are no special arrangements in place, that money just goes into the general body available to pay a dividend to all of the unsecured creditors. Let's look at the situation as it will apply when the legislation does work in a modern situation. So we'll assume here that the creditor is able to make the claim stick, and the insurance company realizes it's covered, they have to pay out, and they do pay out. And in a case like that, yes, you can expect the creditor to receive the compensation directly. So it will bypass you as liquidator. The insurance company will pay directly to the creditor. And that means that the money is not available to you in the liquidation. In some ways, this does actually make life a whole lot simpler for you, because it's just something that you do not have to deal with. It becomes an issue purely between the creditor and the insurance company themselves, rather than something that you have to deal with as liquidator. But life is never always as simple as that. And so let's have a look at the rights next that the creditors actually have and see how those might affect you as a liquidator, for example. This is the way that the legislation works, that when the creditor has got a claim which is covered by insurance, then the claim that the company would otherwise have against the insurer is automatically transferred to that creditor. And the time when that claim is transferred will be either at the moment when you are appointed as liquidator, whatever office you're holding, or if the claim arises post-appointment, at the time when the claim arises. So it's something that never actually falls within your ambit as liquidator, because the claim has effectively been assigned out of the insolvent estate before you get a chance to deal with it. And the effect of that assignment is similar to what it would be if the creditor had security over the insurance claim. The creditor, the third party in the terminology of the legislation, the creditor is still a creditor in the liquidation, but only for the shortfall, only for the amount it cannot recover from the insurance company directly. And because the company's rights against the insurance company have been transferred to the creditor, you as liquidator have got no right yourself to pursue a claim against the insurance company, even if there are losses arising out of this incident that you yourself would want to recover. The whole claim has been transferred to the creditor. The creditor does not get any better rights than the company itself had in terms of the claim that can be pursued against the insurance policy. So if, for example, the creditor is to some extent to blame themselves for the loss, and if they made a claim against the company, you'd be entitled to reduce their claim for contributory negligence. The insurance company would have exactly the same right to reduce the claim for contributory negligence. Also, the claim, when it is transferred, will be subject to any pre-existing rights of set-off. For example, the company may have failed to pay the last insurance premiums. And in that case, the insurance company will be able to set off what the company owes against the amount that it pays out before it transfers the payment to the creditor. The really nasty one, as far as the creditor is concerned, is that if the insurers have got the right to void the policy, then they still keep that right. So the creditor might find themselves trying to pursue a claim against an insurance policy only to find that the insurance company disappears as it is voided by the insurer. There are anti-avoidance rules in the legislation, so insurers are not allowed to void policies simply because the company has itself gone into liquidation. If there was a claim that arose before the liquidation, then it can still be pursued. But the sort of situations when insurers might be able to void the policy would be at the time when the policy was being set up and renewed, if there was a material non-disclosure to the insurer, or at the time when a claim is being processed, if the insured, meaning the company in liquidation, is not cooperating sufficiently with the insurer in dealing with that claim. Now, I'm going to touch on that a bit later because I think there is an area of potential risk for you in that if you have a creditor making a claim against the company's insurance policy, you're not involved in that, but you might find that the insurers themselves want information and cooperation from you. And if you don't provide that, then the policy could be avoided, in which case you would have a very aggrieved creditor who would be blaming you, the liquidator, for that. And I don't know the extent to which you would actually have a duty of care to prevent that from happening, but towards the end of this presentation, I'll have some suggestions about how to mitigate the risk of that for you. So that's looking at the basic rights that the legislation will give to a creditor. Let's move on now to look at how the creditor will enforce those rights. What steps must they take to ensure that they get what they are entitled to in the case that is applied? There's one primary right and two supplementary ones. The primary right that the creditor has got is the right to sue the insurer. And this is what normally happens, is that the creditor, rather than suing the company in liquidation, will sue the insurer directly. In fact, litigation lawyers, being, I suppose, quite cautious creatures, chances are they will probably sue the company in liquidation as well as suing the insurer. If it's an administration, they may not ask for leave to do that because they're lawyers usually who do not have a great deal of experience with insolvency. So you may find that you are having to guide them through what they need to do and what they don't need to do in terms of making sure that it's all done correctly. That's not likely to be the first point of contact you have with the creditor on this. They're likely to start by demanding information about the insurance policies that the company had got, so that they can see who they can make the claim against. And they have a right to that information, so you'll have to cooperate to that extent. The other thing that the creditor is entitled to do is they're allowed to do stuff that the company itself, as policyholder, was supposed to do. And the classic example there is that somebody should normally put the insurer on notice of a potential claim. You as liquidator have got no particular interest in doing that, but the creditor in this case is entitled to do that and is entitled to put that notice in directly to the insurance company. So let's go through a short timeline of that just to show how it all might work in practice. And we start here with a claim arising. The company has done something to a third party, we'll call them the creditor, that gives them a right to compensation. And the circumstances of this are that, fortunately, the company has got insurance to cover at least some of the cost of that claim. And at some point, the company defending the claim has gone into liquidation. And the result of that is that that liquidation transfers to that creditor the right that the company had to make a claim on its insurance policy. Therefore, the creditor can make that claim directly from the company's insurer, and assuming that the claim is successful, the payment bypasses liquidation. So the funds are not available to pay the general body of creditors. The insurer will pay out directly to the creditor pursuing the claim. Here's an example, just reported a few weeks ago, the case of Boscolo. And this was a case where Boscolo was contracted to refit the interior of an apartment. It must have been quite a substantial piece of work, but it seems that it wasn't done terribly well. The customer was very dissatisfied and actually wanted to sue Boscolo for breach of contract. Good news was that Boscolo did carry indemnity insurance against claims of this sort. The bad news was that the cap on claims under the insurance policy was £250,000. The claim that was being made against the company was over £700,000. The insurers were told of the claim. The insurers looked about this and they could see that they were on a hiding to nothing about this. They made their assessment of the claim and worked out that it was going to come in at substantially more than £250,000. The insurers decided that they didn't want to have any further part of the battle about this cover. Insurers would normally instruct solicitors and would normally try and defend the claim. They decided that was just good money after bad. They weren't going to do that. So they paid the full amount of the cover that the company had got, the full £250,000 to the company, and said, there you go, we're washing our hands of this. That's what you'd be entitled to under the policy as an absolute maximum. We're paying to you now. We've got no further obligation to you under the insurance policy. It may be because of the litigation, it may be for some other reason, but Bosco, though, they went into creditors' voluntary liquidation. They did so fairly soon after the insurance money had been received, and they quite properly paid all of that money to Begbie's, who were the properly appointed liquidator of the case. The creditor was not happy about this. The creditor did not want liquidator to distribute this money as a general asset in the liquidation to the body of creditors. The creditor claimed that because of the workings of this piece of legislation, that money should be treated as being held on trust for the creditor, because the creditor's rights under the policy would be assigned on the liquidation anyway. The judge disagreed. The judge ruled here that the liquidation had assigned whatever interest the company had got in the policy for that creditor to the creditor. But by the time the company went into liquidation, the company did not have any claim against its insurer for that, because the insurer had discharged whatever obligations they'd got by paying the full £250,000. Therefore, £250,000 was an asset in the liquidation and was available to pay the expenses of the liquidation and then a dividend to all creditors in accordance with the normal statutory order of priority. And in this particular case, the creditor could not claim to be any higher up the ordinary order of priority through the circumstances of this. I think that's a useful illustration of the way this can work. So that covers what creditors have to do to enforce their rights. Let's look now at the insolvency procedures where this legislation applies. And in the field of corporate insolvency, it's a pretty comprehensive list. It's all types of liquidation, including MVLs and including provisional liquidations. It's administrations, including all of the special administration regimes. Receiverships, it's a bit less clear-cut, and it looks like court-appointed receiverships are outside the scope of the legislation. Voluntary arrangements are in. Part 26A restructuring plans are in, and so are the previous, still existing form of scheme and arrangement under Part 26 of the Companies Act. They're all covered. The main exclusion from this list, the main procedure that is not caught by the Act, are the statutory moratorium procedures. Looking at personal insolvency, again, it's a similarly comprehensive list. It's bankruptcy, including insolvent estates, it's voluntary arrangements, it's DROs, it's county court administration orders, and it's also county court enforcement restriction orders. Now, if you haven't heard of a county court enforcement restriction order, don't worry, I hadn't heard about it either, and that's because they haven't been brought into force. So almost any type of conventional insolvency procedure will trigger creditors' rights under this Act and will transfer the opening of the procedure, whatever rights the debtor had against the insurance company, to creditors who might bring a claim that the company would seek to have indemnified from its policies. So those are the procedures to which this applies. Let's look now at what your duties will be as an office holder if you have a creditor looking to enforce their rights when you're in office. So your main duty is actually to give information about the insurance. Remember that that's statutory requirement to give information within 28 days. Now, the reason why you have to give information is not because you are the office holder as such. It is because, as office holder, you are somebody who can be expected to have information about the debtor's insurance. And therefore, because you have information about the statutory insurance, you're one of a number of people from whom the creditor can demand that information. And you have got to reply within 28 days. And within those 28 days, you have to either provide the statutory information, or if you can't provide the statutory information, you have to say why you can't provide it. And if the reason is because you pass it to somebody else. So if, for example, you've sold the business, and when you sold the business, you passed all of the insurance records to the new owner of the business, you'd have to explain that that's what's happened and who it is who now has possession of the records. The creditor has got the right to get a court order against you to compel compliance if you don't comply. Because you have, as office holder, statutory rights to information from the debtor, that actually puts you in a position where you are very much in the target for this. And simply saying the debtor hasn't handed the documents to me is unlikely to be a sufficiently satisfactory answer. And again, remember that when you encounter a request like this, there's likely to be a firm of litigation solicitors involved. They're probably the ones who are writing to make the request. They'll know that they can apply to court within 28 days, and they will not have any hesitation in doing that. So you really do need to comply with this request so far as you can. This is the information that they're entitled to receive. Again, you'll probably find that they'll list this in the letter that you receive. They're entitled to know whether there is insurance that could cover the claim, who the insurer is, and to receive a copy of the policy. They're entitled to know if the insurer has declined cover, whether there is any litigation between the company and its insurers about the cover. So if there's any sort of dispute there about it, they're entitled to know about that. If there's a cap on the policy which has already been eroded through other people making claims, then they're entitled to know how much of that cap remains in place. And if there is a fixed charge on the policy, they're entitled to know about that as well. You may not know whether there is a fixed charge. You can probably answer that question simply by saying you're not aware, you've not investigated, but you would expect any such charge to be registered at Companies House in the usual way, and suggest that you check his house and get hold of copies of the charges from there. It's not every creditor who has this right to go fishing for information about insurance policies that the company has got. They will have the right, as a result of the company going into insolvency, if a policy has been transferred to them. But the 2 points that trigger the right, as far as you're concerned, is if you have a creditor who thinks that they have a claim against the company, and they think that the company was insured against the claim. So when they write to you, they should be giving information about the claim to show that they've actually got some reason for thinking there's a claim, and they should explain why they think that the company may have carried insurance against it. But that's a fairly low bar for them to get over. So that's a quick run through the duties that you have got to a creditor making a claim. Let me now make some suggestions to you about how perhaps you could deal with threatened claims under this legislation. So there are 3 points I want to cover here. Firstly, MVLs. Secondly, requests for information that you might receive. And thirdly, when you get a creditor asking for more than the statutory information. So dealing with each of those in turn. With an MVL, I mean, you wouldn't want to be appointed as liquidator of a company in an MVL where there is a possibility of an insurance claim or where there is an existing insurance claim. You'd want to look very, very carefully before taking that on as an appointment, I should think, even if it's covered by insurance. But if you should find yourself looking at an MVL in that sort of situation, these are the key points to remember, I think. Firstly, that the MVL will transfer the rights to the insurance policy to the creditor. That's automatic. There's no opting out of it. It will happen. It's a force of nature. So the insurance policy itself will no longer be an asset in the MVL. And remember that that could have consequences if the company itself was looking to get some sort of compensation from the insurers arising from the same claim as the creditor has got. It does mean that following your appointment, the creditor will deal directly with the insurer. That may be something you think is a useful thing to do. It could be that the directors think that it would be sensible simply to pay the excess to the insurance company and then wash their hands of the whole thing, walk away from it and leave it for the insurers to deal directly with the creditor over how much is ultimately paid out. However, it may make it harder to make a quick settlement if you leave it to the insurers, because the company itself will no longer have any say in the timetable over it all, and it may result in you having to keep the MVL open for longer, particularly if you get drawn into, the company gets drawn into having to provide evidence, documents, information to the insurance company to try and defend the claim. And remember, of course, if there's insufficient cooperation with the insurance company, the insurers may have the right to avoid the policy. And if they do, then the creditor will have the full value of the claim against the company without the benefit of insurance. To the extent that the insurance doesn't cover the claim in full, then the creditor will still be a creditor in the MVL and will have to be admitted, which is why I suggest perhaps paying the excess either directly to the creditor or to the insurer might be a way of dealing with that. Or there may be some other settlement that you could come to with the insurer and the creditor about that. So that's dealing with a claim that comes into an MVL. Let's look at how you should deal with requests for information. This is just a recap on what I said earlier. Do take the request for information seriously. Remember, there is a risk of a court order against you if you do not comply promptly. And if the creditor applies for a court order, they're likely to ask the court to award legal costs against you as well. You've got only 28 days to deal with it, so it's not something that you can treat as a low priority. You do have to sort it out in that time. But don't be shy about asking for an extension of time if you think that you need it. And if you think you need an extension of time, it's usually better to ask for that early in the 28 days rather than on day 26. And if you can't deliver everything at once, then certainly deliver what you can and explain perhaps why you're not able to complete the rest of it. I don't think it's going to be reasonable for you to ask for your costs to be covered in complying with this. This is all information that should be readily available. It shouldn't take a huge amount of time to provide it. And I think it might just look like you're being difficult if you ask for your costs. It might trigger an application to court against you. But I'll talk about this in a bit more in a minute. There are circumstances when it is reasonable to ask for your costs to be covered. Finally, do not destroy your file. Whatever your normal policy might say, you might have left office 11 months and 28 days ago, and you might be due to destroy the file on Thursday. if a request for information comes in, do not do it. It's never a good look to be seen to be destroying potential evidence as litigation starts. So you will actually have to keep all of the files once that aim comes in. And remember as well that the duty to provide information is a duty because you have got information, not because you are in office. So it's a duty that will continue even after you have left office, for as long as you have got a file of papers. Of course, this is a reason why you should destroy your file of papers pretty promptly once your policy suggests that you've got the right to do that, but only if there has been no claim that has come in when you do that. Final point to look at here is what happens if you have the insurer asking for information above the statutory minimum, or the creditor asking for information beyond the statutory minimum. This is a balance here, because if you just give a blanket refusal, then the policy might be avoided, and you might then have a creditor claiming that they've got a right to claim against you, that you owe them some sort of a duty of care, or to make sure that that doesn't happen. So the way I suggest that you deal with that is to ask at the earliest opportunity for your time and expenses to be covered, to explain that you are entirely willing to help, but you cannot do so at the expense of the unsecured creditors, and it's not reasonable to ask you to work for free. Therefore, you should have your time and expenses covered. And I've had a situation where it was a CVL, and the insurer wanted a lot of information from the liquidator. We said, happy to do it as long as our costs are paid. The insurer's solicitor said, that's a very unusual request. The whole point of the insurance policy is to protect you from claims. If you don't help, we may void the policy and you won't be protected. And we said, that's fine. If you void the policy, it's not actually protecting us anyway. It's protecting the company. And in the circumstances, it won't make any difference to the unsecured creditors if the policy is avoided. So if you think you should avoid the policy, go ahead and do that. But we are willing to cooperate as long as our expenses are paid. And the insurer in that case, with great reluctance, did agree to cover at least some of the expenses incurred. And if there is litigation between the creditor and the insurance company, and if you get a request for information, that's obviously the direction it's going down, then you may find that you're drawn into the issue of disclosure of documents, and that can be a huge operation, and you would certainly want to get your costs covered for that. We actually do a coffee break briefing on this a year or two ago under the heading of zombie litigation, the sort of litigation that carries on despite the fact the company has gone into liquidation. So if you're interested in knowing a bit more, then have a look on our website at that previous presentation I gave. And I think that is now bringing us to the end of the presentation. I don't see any questions that have come in. If you didn't hear the announcement that I made at the start of this presentation, can I ask you just to hang on to the line for a couple of minutes so I can repeat it to you? But other than that, this is the end of this morning's presentation. Thank you very much for your attendance today.